Good morning, good afternoon, or good evening, everyone, depending on where you're joining us from around the world. My name is Richard Anderson, and I'm the founder and CEO of ShareVault. I would like to thank you for joining us for our webinar today. This is the 29th in ShareVault's webinar series, and today's topic, Raising More Capital Through a Regulation A+ Offering, is especially timely in light of the SEC's recent issuance of new rules amending the way organizations can raise capital or increase liquidity utilizing provisions under Title IV of the Jobs Act. At ShareVault, we frequently work with companies seeking growth capital and managing complex, multi-party transactions where confidential information is shared with prospective investors during the due diligence process. ShareVault is used in many types of transactions such as mergers and acquisitions, private placements, venture capital financings, public offerings, and restructurings, similar types of transactions to those represented by Regulation A, which our speaker will be covering today. We'd like to thank our co-sponsors, Morrison & Foerster and Command Financial Group, for suggesting the topic, providing the content, and helping to publicize this webinar. Morrison & Foerster is a global firm with exceptional credentials. Their clients include some of the largest financial institutions, investment banks, Fortune 100 technology and life science companies. They've been included in American Lawyer's A-list for 12 straight years, and Fortune named them one of the 100 best companies to work for. MoFo lawyers are committed to achieving innovative and business-minded results for their clients while preserving the differences that make them stronger. Command Financial Group has distinguished itself as a trusted expert in document lifecycle management and financial printing solutions. Command has worked with many large corporations, law firms, investment management firms, and private investment firms around the world, and has consistently provided them the highest level of quality across a wide variety of document management and printing services. And finally, ShareVault is the innovation leader in providing virtual data rooms and secure document sharing solutions that allow businesses to control and track the sharing of confidential documents with external parties during due diligence and other critical business processes. ShareVault is an on-demand web application that provides bank-grade security and the highest degree of reliability, combined with unparalleled speed, ease of use, and functionality. Before I introduce today's speaker, I'd like to briefly cover a few logistical items. First, although your individual audio will be muted in order to minimize background noise, we do encourage you to submit questions at any time during today's presentation via the question box located in your webinar control panel. Secondly, there will be a question and answer session following the presentation. We hope to get to all of your questions, but if time does not permit, we will make every effort to respond to your question by email after the webinar. And lastly, our speaker has generously offered to make a recording of today's presentation available. You'll be notified by email when the recording becomes available online. You'll also receive instructions to log into a ShareVault secure document sharing system to download the slide deck. It is my pleasure to introduce Anna Pinedo, a partner with Morrison & Foerster. Ms. Pinedo has concentrated her practice on securities and derivatives. She represents issuers, investment banks, and investors in financing transactions, including public offerings and private placements of equity and debt securities, as well as structured notes and other hybrid and structured products. Ms. Pinedo works closely with financial institutions to create and structure innovative financing techniques, including new securities distribution methodologies and financial products. Ms. Pinedo has been included in Best Lawyers in America, Euromoney's Expert Guide for Capital Markets and Expert Guide for Women in Business Law, Chambers and Partners USA and Global Guides, the Legal 500, and International Financial Law Review 1000. We are thrilled to be with you today, Anna, to learn from you as we discuss this very timely business topic. So welcome, and please feel free to begin your presentation.
Okay, great. So beginning with the agenda on slide 5, as indicated, I'm going to provide a very quick synopsis or overview, delve into some of the basics of Regulation A+ and the requirements, and then spend a fair bit of time going through the disclosures and the actual offering process, and then wrap up with a discussion of how issuers and financial intermediaries might think about and compare and contrast the opportunity to raise capital using Regulation A with other offering exemptions, as well as with a traditional IPO as an emerging growth company in reliance on Title I of the Jobs Act. So moving right along to page 7 and Title IV of the Jobs Act. So long before the Jobs Act was even contemplated, there were a number of initiatives to amend Regulation A. Regulation A has been around since the 1930s, almost since the Securities Act was adopted, and it's always been an offering exemption. It's not a private placement exemption, but an offering exemption that was intended to facilitate capital raising by small companies, recognizing that small companies needed a cost-efficient means of raising capital in small amounts. The principal issue with Regulation A before these changes was the low dollar threshold. So before the Jobs Act, the dollar threshold for Regulation A was $5 million of offering proceeds in a 12-month period. So what Title IV of the Jobs Act did was create a new section, Section 3B2, that effectively mandated that the SEC adopt rules providing for an exempt offering of up to $50 million in proceeds for smaller companies. The statute set some parameters, which you see there at the bottom of slide 7 and continuing on to the top of slide 8. But the SEC was given a fair bit of discretion in terms of many of the detailed requirements of the rule. And the SEC had the benefit in formulating the rules of the results of a GAO study. On slide 9, you'll see that Title IV of the Jobs Act also required that a study be conducted by the GAO to understand what the principal impediments were that prevented broader usage of Regulation A. And what the GAO study found was that on a comparative basis, issuers that were trying to raise capital had Regulation D, and specifically Rule 506, available to them, which permits companies to raise an unlimited amount of capital in a private offering made to accredited investors. And that was considerably more attractive than the limitations associated with then Regulation A and its $5 million threshold, as well as the requirement under Regulation A to also subject the offering to state review, to blue sky requirements. So with this learning, the SEC adopted final rules, and those rules, as we see on slide 10, became effective this summer. So the final rules became effective in June. We have, as a result, a fairly compressed time period on which to base our comments. And as with all new things, it will take a while for the market to absorb the changes and for market participants to sort of get accustomed with Regulation A and how to incorporate Regulation A in their toolkits for financing. So hopefully sessions like these will get people thinking about the various uses for Regulation A in financing plans. The final rules essentially amend and modernize existing Reg A and create two tiers of offerings. So a Tier 1, which is anticipated to be for companies that are in earlier stages of development, although, again, it's not limited to that. Any issuer of any size, provided it's as we'll see in a moment, provided it's not an SEC reporting company, can avail itself of Regulation A, Tier 1 or Tier 2. So Tier 1, a company can choose to rely on Tier 1 for offerings of up to $20 million. And Tier 1, is subject to state blue sky review, or conduct an offering in reliance on Tier 2 for offerings of up to $50 million. Just to address a common misconception, you can rely on Tier 2 to raise anywhere from $1 to $50 million. So you shouldn't think of Tier 2 as just offerings of between 20 and 50. It's really a choice, and that becomes very important, as we'll discuss in a little bit. The final rules set out the requirements in terms of issuers that are allowed to participate, the types of securities that one is allowed to sell, the disclosure and the reporting requirements. The ongoing reporting requirements differ as between Tier 1 and Tier 2, as we'll talk about in a little bit. So that's a very broad brush overview. Now delving into some of the principal requirements, if we go to slide 12, who can rely on Regulation A? So for now, it is limited to issuers that are organized and have their principal place of business in the United States or Canada. For any companies that are considering relying on Reg A, it's important to look at the actual final rule, but very helpfully, the SEC staff issued a number of compliance and disclosure interpretations that provide a lot of helpful guidance on questions about who can and can't use Reg A. So organized in the US or Canada, you cannot use Reg A if you're already an SEC reporting company, if you're a fund that registers under the 40 Act, a blank check company, if you're a bad actor, if you've relied on Reg A in the past but been delinquent in filings, and so on. So there are various types of entities that become subject to disqualification. As we see on slide 13, there was some inquiry at the time of the proposed rules as to whether REITs should or shouldn't be allowed to rely on Reg A. They are indeed eligible issuers. Likewise, just a few clarifications. A Canadian issuer that already has a class of securities that are listed and traded on an exchange in Canada would still be considered an eligible issuer in the United States and could rely on Reg A. So that opens a number of interesting possibilities up. For example, a Canadian issuer that wants to do a transaction and is looking for an exemption on which to base its sales to U.S. investors, Reg A would be a possibility. Reg A can also be used in the context of a merger or an acquisition. A public company can use Reg A if it wants to raise capital through or for by a subsidiary, which obviously is not a separate reporting company. So there are a good deal of situations where one could envision that Reg A could be used. Also, if you have a company that once was a reporting company, subsequently deregistered, it also could become or be an eligible issuer for Reg A purposes. On slide 14, you will see the eligible securities. So the only securities really that aren't permissible are asset-backed securities. And that makes sense since it's very unlikely that companies would want to use an asset-backed security in the context of an early capital raise or as their first entree into the market. If we go to slide 15, you'll see the offering limitations. So as I alluded to previously, two tiers. Tier 1, where you can offer and sell up to $20 million in any 12-month period. And of that $20 million, up to $6 million could be sales by existing security holders. and Tier 2, where the issuer can sell up to $50 million, and the selling stockholder component can be up to $15 million. There are some special rules for the first Reg A that an issuer does. So the selling stockholder component can't exceed 30% of the aggregate offering. After that first year, if we go to slide 16, following the initial qualification of a Reg A offering statement, that limit on secondary sales falls away for non-affiliates. So obviously the point here is that the SEC was looking to create liquidity and looking to provide liquidity opportunities for existing security holders without creating potential conflicts of interest with interested stockholders or affiliates. If we go to slide 17, you'll see that there's an investment limitation. This investment limit only applies to non-accredited investors, so it doesn't apply to institutions. Institutional accredited investors, you're only dealing with this in the context of non-accredited natural persons. And for those of you who follow the crowdfunding market, this may look familiar in the sense that in the SEC's proposed crowdfunding rules, there was also this notion of an investment limit. The investment limit doesn't apply to accredited investors, also doesn't apply if in conjunction with a Tier 2 Reg A offering, the issuer is going to apply to have its stock listed on a national securities exchange like NASDAQ. And the principal motivation here for adopting these investment limits rather than relying solely on securities disclosures was to ensure that there was yet another measure of investor protection. If we go to slide 18, the final rules for Regulation A provide a limited exemption for securities that are issued in Tier 2 offerings from the Section 12G holder of record threshold. Just a quick reminder, there are two ways that companies can become fully subject to SEC reporting requirements under the Exchange Act. One is if they affirmatively undertake an IPO and choose to list their securities, and the other is if they trip the shareholder, the holder of record threshold in 12G, which was amended in conjunction as a function of Title V and Title VI of the Jobs Act. So in order to have this limited exemption from the holder of record threshold, the issuer has to hire a transfer agent and will only have to worry about crossing the 12G threshold with this somewhat phased transition period, the 2-year transition period that is described there as the last bullet. So this is very helpful if a company, for example, is doing a number of Reg A offerings over a period of years, or if the company, for example, is doing Reg A offerings, but also doing some Rule 506 offerings and conducting a series of private or exempt transactions, it's going to have to be very mindful of the number of record holders and when and how it trips the 12G threshold. Slide 19. Again, thinking about investor protection issues and liability issues, it's important to note that under Regulation A, there is Section 12A2 liability for distribution participants. And of course, all the other anti-fraud statutes apply as well. In preparing an offering circular in preparing any test the waters materials. It's important for issuers, for any kind of intermediary, even if it's a platform that's not a registered broker-dealer, which I'll get to in a moment, to be very mindful that liability attaches in the context of a Reg A offering. So it's essential to avoid material misstatements or omissions. So those are some of the basics. Now we're going to delve into the disclosure requirements and the offering process. Among the steps that the SEC took to modernize Regulation A was to ensure that participants in a Reg A would be able to file on EDGAR and use the EDGAR filing system. So as you see on slide 21, offering statements for Reg A transactions have to be filed with the SEC on EDGAR. Subsequent, for Tier 2 transactions, the ongoing reports have to be submitted to the SEC on EDGAR, so they're going to be publicly available. The final rules adopt the same principles of access equals delivery that apply under Rules 172 and 173 for public offerings. So in terms of the actual materials, if we go to slide 22, there is the Part 1 notification, which is a very streamlined and basic form. Just asks for issuer, eligibility, some offering details, basic information about where the securities are going to be offered. And then the more time-consuming and expensive part of the process we begin discussing on slide 23, which is the offering circular, so Part 2. And you might think of the offering circular as sort of a slimmed down S1 registration statement. So the type of information that's requested is going to be awfully familiar to most securities lawyers and to issuers who have engaged in multiple rounds of financing in the past. So risk factors, use of proceeds, a business discussion, an MD&A type discussion on financial results, basic information about executive officers, directors, their compensation, and so on. All of the disclosure requirements, as we note on slide 24, are scaled, meaning that everything is kind of graduated, given that it was anticipated that most of the companies that would be using Reg A would be smaller companies, companies in an earlier state of development. To the extent that an issuer that's using Reg A is in a particular business, so oil and gas, real estate, financial services, then the SEC's industry guides are applicable in terms of informing the disclosure requirements. So we mentioned, for example, there, Guide 5 for REITs. And then a Part 3 with exhibit requirements. And the exhibits, again, the exhibits that are required to be filed will be familiar to anyone who has done public filings. So basic charter type documents, material contracts, legal opinion on legality of the validity of the shares that are being offered. In terms of financial statements, so go to 25, we spend a fair bit of time talking to interested companies about the financial statement requirements. So here's one of the areas where there are important differences between Tier 1 and Tier 2. Both Tier 1 and Tier 2 issuers have to file balance sheets and other required financial statements as of the two most recently completed fiscal year ends. And then probably most important, or for any shorter time as they've been in existence. So obviously a company that's just recently started its business has to file for the period in which it has had operations. The financial statements for an issuer in a Tier 2 offering have to be audited by an independent auditor. It doesn't have to be PCAOB registered, except to the extent that the Tier 2 issuer is going to, at the end of the Reg A transaction, apply to have its securities listed on a national securities exchange. If we go to the next page, page 26, we'll see there that very similar to the process for emerging growth companies under Title I, a company that's thinking about doing a Reg A wants to explore the possibility, can submit its offering statement for non-public review. So that's available, and have the offering statement commented on by the SEC, respond to those comments, etc., provided that the offering statement is publicly filed at least 21 days before it's qualified. So you can think of, although there's some differences, you can think of qualification of the offering statement as equivalent to the SEC's declaring effective the registration statement. So basically, at such time as the SEC has no further comments. One of the great advantages of a Reg A transaction is that an issuer can test the waters, as we describe on slide 27. So an issuer that's thinking about doing a Reg A can actually use marketing materials with appropriate disclaimers, and attempt to solicit interest, see if there would be investor appetite for an offering. Prior to confidentially submitting its offering statement, during this confidential process, while the SEC is reviewing it. So there's a fair bit of opportunity for communication that might not exist with some of the other securities exemptions, with other exempt transactions. And there's been a fair bit of press about a number of companies that have really availed themselves of the opportunity to test the waters and have used the internet to try and gain some sense of whether there'd be market interest in a transaction. Ultimately, materials that are used after an offering statement is publicly filed would have to be filed with the SEC and would be publicly available. So, of course, market participants are going to want to be very careful about preparing those test the waters materials and making certain that any test the waters materials are fair and balanced in their presentation of the company, the investment opportunity, the risks, and so on. I mentioned that one of the key differences between Tier 1 and Tier 2 is what's required in terms of financial statements. The other key difference is what happens after the transaction. So an issuer that completes a Tier 1 offering has very limited post-closing or ongoing reporting obligations. It really only has to file an exit report, a Form 1Z, 30 days after the offering's been completed or abandoned. And meanwhile, by contrast, a Tier 2 issuer is going to be subject to ongoing reporting. So as I note there, it's very important to spend time up front really thinking about what the issuer hopes to accomplish by virtue of doing a Reg A offering, whether the issuer expects to and wants to use the Reg A, if it's a Tier 2 offering, as an opportunity to have a public presence, be better known to competitors, to potential strategic partners, to others through the offering process and afterward through the ongoing reporting, or whether its sole aim is just to raise a certain amount of money. So a lot of this will be just a balancing act in terms of the other offering exemptions that are available, the type of investor that the company wants to attract, how it wants to communicate the news about the offering, and then weigh that all against the costs associated with the ongoing reporting requirements involved in a Tier 2 transaction. So going into a little bit more detail about those, if you go to slide 29, a Tier 2 issuer is subject to a requirement to file an annual report, so Form 1K. A little bit, these periods you'll see for filing are a little longer than what an IPO issuer would have for, let's say, a 10K or a 10Q. A Tier 2 issuer does not have to file quarterly reports. It is only required to file semi-annual reports. There's an equivalent to an 8K, which are these current reports on Form 1U. And current reports are required for some specified events. So on slide 30, you'll see current reports are required for bankruptcy proceedings, changes in accountants, changes in control, non-reliance on financial statements. So a smaller universe or a subset, you might say, of the 8K triggering events. On slide 31, we talk a little bit about whether for a Tier 2 issuer, all of this ongoing reporting and this public information would be deemed sufficient in terms of the current information requirement for Rule 144 and 144A. So the securities that are sold in a Reg A transaction are not restricted securities. By comparison, for example, to securities that are sold in a private offering under Section 4A2, or securities that are sold in reliance on the Rule 506 safe harbor. But in order for a holder to be able to resell the securities, it has to be able to rely on Rule 144 or another exemption. And so a Tier 2 issuer that wants to facilitate resales likely will just voluntarily submit quarterly financial information so that its public information would be sufficient for holders to rely on Rule 144 for subsequent transfers. The other alternative for liquidity would be for the issuer to regularly provide a liquidity opportunity for existing security holders. And an issuer could do that relatively easily through something like NASDAQ's private secondary market, or through issuer repurchases, or by facilitating transactions among existing stockholders. On slide 32, we have some information about suspending or terminating reporting obligations. So a Tier 2 issuer doesn't have to sort of continue with its reporting forever. It can decide to suspend its reporting obligations, as you'll see there, relatively easily. And but again, this is going to depend on what the issuer's principal purpose for the financing was. If it decided to take on the expense associated with a Tier 2 offering, it's prepared the disclosures required in the offering statement for a Tier 2 offering, and then has been engaged in ongoing reporting. It's unlikely that it's going to want to just terminate or suspend its reporting obligations and leave security holders really without an opportunity for liquidity. Just to finish up the process discussion a little bit before we turn to some of the state law issues, as we discussed on slide 33, to the extent that an issuer is enlisting the help of a broker-dealer who's going to act as a placement agent or as an underwriter in the Reg A transaction, that placement agent or broker-dealer who is a FINRA member is going to have to submit to FINRA for review the Reg A offering statement. And just relatively recently, FINRA put out a notice that provided some clarification regarding the FINRA review process for a Reg A offering. So that's out there and is very helpful as a point of reference. The other question that we get asked quite frequently is whether an issuer has to have a broker-dealer assist in a Reg A. Indeed, an issuer could effectively conduct a Reg A on its own without an intermediary, using the internet, using its network of friends, family, existing security holders. So it's not required that there be a broker-dealer acting as placement agent or underwriter. Again, it's very much going to be a function of what the issuer intends by way of the offering. For example, if the issuer is conducting the Reg A offering as an opportunity to have its company known and to reach institutional investors as well as some retail investors and position the company for its next steps, it may well benefit from having a broker-dealer placement agent that's going to help with the testing the waters materials, going to help with and comment on the offering statement disclosures, particularly the issuer's business description, arrange for investor meetings, roadshow presentations, and so on. The other point that I wanted to mention is, in this context, is that there are a number of portals, so internet-based financial intermediaries that have arisen. Portal is a concept that's applicable only in the context of a Title III crowdfunding transaction, where you have a funding portal, kind of a broker-dealer light model, or a broker-dealer, and one of the two, either a funding portal or a broker-dealer, is required for Title III crowdfunding. We don't have final rules for crowdfunding yet, but it's in that context that a funding portal is required. And a funding portal is a type of registered entity. Of course, since we don't have final Title III rules, an intermediary can't yet register with FINRA and with the SEC as a funding portal. And if there's an intermediary and it's choosing to take transaction-based compensation, in other words, if it's going to receive a percentage of the amount that it raises, then it would have to be a registered broker-dealer. It's important for companies to be aware that there are many regulatory issues with using an unregistered finder in the context of a securities transaction. So given the time, I'm just going to move along to make sure we get to some of the most important discussions. And a last point here on process. Reg A does permit an issuer to do a continuous offering. So for example, Reg A could be used in connection with employee compensation, like a DRIP, an employee benefit plan, or something along those lines. Not, however, in connection with an at-the-market offering. So now I'm going to turn to state law issues. Again, the area that most potential issuers ask about. So the final rules provide that Tier 1 offerings, the smaller, under 20 million, remain subject to state securities law requirements. So that means that if you're doing a Tier 1 offering, you will be preparing an offering statement that's going to be reviewed by the SEC, commented on by the SEC, but also subject to review and comment by state securities regulators. By contrast, a Tier 2 offering is not subject to state review, and the statute expressly provided that to the extent securities were sold to qualified purchasers, the securities would be covered securities, not subject to state review. And so in its final rules, the SEC defined qualified purchaser as any offeree or purchaser in a Tier 2 offering, based on the fact that there are so many robust investor protection provisions built into the Tier 2 framework. And as you can gather from all of the requirements that I went through in terms of what has to be included in an offering statement, the financial statement requirements for Tier 2, it's clear that offerees in a Tier 2 offering have quite a lot of information about the company at their disposal when they're making an investment decision. And so by virtue of that, the Tier 2 offerees are clearly able to fend for themselves, and Tier 2 transactions currently are not subject to state review. Now, this is subject to challenge. So Montana and Massachusetts have challenged the SEC's actions and claim that the SEC exceeded its authority and violated the Administrative Procedures Act in defining the term qualified purchaser in this way. While this litigation proceeds, there's issuers can continue to rely on the fact that Tier 2 offerings are not subject to state review. If we go to the next slide, in conjunction with the adoption of final Reg A, the states, through NASA, established a coordinated review program. So this coordinated review program is intended to make the process of submitting Reg A offerings and clearing Reg A offerings for sale in multiple states to make it easier, more seamless, hopefully more cost efficient. And as part of this process, a state will take the lead and coordinate comments that are received from the other states where securities are going to be sold. There have been, again, it's a relatively new process. There have been a handful of issuers that have availed themselves of this coordinated review process. It's very difficult to make an assessment as to its effectiveness at this point. So but it is important to note that it's out there and is certainly a viable option. As we talk about on slide 38, in thinking about and weighing Tier 1 versus Tier 2, of course, an issuer is going to want to consider the different disclosure requirements, namely the difference in the financial statement disclosure requirements, and that may not be as significant to issuers that have been in business for a relatively short period of time. The financial statement requirement may be more meaningful, or the difference between Tier 1 and Tier 2 may be more meaningful for a company that actually has been in business for more than 2 years and that doesn't have an audit. So that's one thing to weigh. The other thing to weigh is, of course, the ongoing reporting, since there really is very limited ongoing reporting for Tier 1, and there is ongoing reporting for Tier 2. And then again, the issuer's aspirations, what it hopes to accomplish by using Reg A, whether it sees Reg A as kind of a prelude to an IPO, as an alternative to an IPO. So in light of that, the other factor to consider is whether an issuer wants to sell only in a handful of states, whether it really wants to be able to sell anywhere in the United States in reliance on internet-based offers, for example, and if it is inclined simply to avoid the ongoing reporting because it doesn't intend to raise more than $20 million and really deal with the state process. What I would factor in to this consideration is that there are still quite a significant number of states that have a merit review approach and that apply a number of standards that may not be so easy to comply with. So really, before making this Tier 1, Tier 2 decision, an issuer should consult closely with counsel, understand if it's going to be where it's going to be selling, understand some of the offering requirements or some of the standards imposed in merit review states, and then make an informed choice. So to finish up, I just wanted to contrast a little and think through the potential uses for Reg A. So of course, an issuer we lay out here on slide 40 the principal two sort of forks in the road. An issuer can choose to conduct one or more Reg A offerings and remain private, by which I mean not list its securities on NASDAQ or another national securities exchange. Or it can do a Reg A offering and list on an exchange at the conclusion of the Reg A through the short form 8A, and effectively have many of the same results that would have been achieved through a traditional or Title I IPO. So the first path first, Reg A and remain non-reporting. Why would you think about Reg A if that was your objective? So if we go to slide 41, if you're weighing Reg A versus Rule 506, for example, in a Reg A transaction, as I mentioned, subject to the investment limit, an issuer can sell securities to non-accredited investors. And this may be very important. What we've seen is that a number of companies that are consumer products companies where they have loyal customers that know the product, that feel that are supporters of the business and the product. Companies may want to do a consumer offering or affinity offering where they sell to their customer base, and their customer base may include non-accredited investors. And so if their customers may not only appreciate the product but also want to own a little piece of it. So in the absence of final crowdfunding rules, a Reg A offering is a good way to conduct that kind of affinity or consumer offering and reach the non-accredited investors. An issuer may feel strongly that it wants to test the waters, it wants to use general solicitation to become better known and to advertise the offering. However, and I should say that while one can now do that in reliance on Rule 506C, 506C imposes a requirement to conduct enhanced investor verification, and there's still some market resistance to using Rule 506C, and on the part of many different parts of the investment community, whether it's angel investors, investors that are a little skittish about providing personal details for investor verification purposes, existing venture investors or private equity investors who don't feel like 506C is the right approach. A Reg A would allow for testing the waters and for general solicitation without the accompanying investor verification. If we go to the next slide, for companies that do have existing venture or private equity investors, a Reg A offering might well provide a liquidity opportunity for them. While we've all enjoyed and benefited from a really vibrant IPO market in the last couple of years, it's not always the case that every portfolio company is going to be an appealing IPO candidate. And also, it's important to sort of be realistic and remember that IPO windows open and shut. So the IPO market's not always there. A Reg A offering can provide another liquidity opportunity for existing security holders. And as I mentioned previously, the securities that are sold in a Reg A are not considered restricted. So as we go to slide 43, that may broaden the base of potential investors. So some funds, for example, have limits on the percentage of their assets that they can invest in securities that are restricted. Since Reg A securities don't count toward that restricted basket, it may be useful to use Reg A. If we go to the next slide, in final Reg A, the SEC also adopted a number of safe harbors, integration safe harbors. So we always talk to our issuer clients about a plan of financing and try and think about all of their financing needs as opposed to just looking at the specific offering that they're thinking about that day or that week or that month. An issuer could certainly conduct a Reg A transaction, and once that's completed or before it undertakes a Reg A, conduct another exempt offering. And you'll see on slide 44 that there are some very clear and very helpful safe harbors from integration. So a Reg A offering is not going to be integrated with another exempt offering that meets all of the conditions for its exemption. Also, in the final rule, there are some helpful helpful clarification since, as I mentioned, in a Reg A transaction, you can use test the waters. That may blur the lines in terms of when a Reg A, when an issuer is testing the waters and actually decides it's going to suspend its Reg A and then turn to another offering format. You'll see on the next two slides, slide 45 and slide 46, that the final rule provides for clarification along the lines of Rule 155 in the private-public context for how to think about Reg A offerings that have been abandoned. So another alternative would be to do a Reg A offering and we go to slide 47, to do a Reg A offering and to file a Form 8A, provided the issuer meets the listing requirements, and list the securities on a national securities exchange. So if an issuer does this, they meet the, let's say, NASDAQ listing requirements, they list on NASDAQ, they then will become subject to full Exchange Act reporting requirements, the corporate governance rules of the exchange they list on, to SOX requirements, and so on. But it is a way of conducting an offering, so raising capital and having your securities listed on a national securities exchange in a way that might be a little bit more cost effective and perhaps a bit faster than a traditional IPO done under Title I. So as we describe on slide 48, a Reg A offering also could be a stepping stone to an IPO. So a company may not feel like it's at that IPO readiness stage. It might want to do a Tier 2 offering, get used to the notion of some ongoing reporting, albeit on the scaled back version associated with issuers who've done Tier 2, maybe staff up, improve its accounting and other functions, and then come back and do an IPO. And one of the great things is that it will qualify as an emerging growth company when it comes time to do its IPO. So that's another way to think about things. Finally, on slide 49, we also think that a Reg A may be a way of structuring what has now become very commonplace, which is a private financing or an exempt financing before an issuer undertakes its IPO. So it's often referred to as the pre-IPO private placement. You could envision doing a pre-IPO financing as a Reg A transaction. And so with that, I believe that we are getting close to the end of our time, so maybe I will ask for any audience questions. Okay, so we have a question, the difference between Reg D and Reg A. So as I talked about a little bit during my presentation, under Rule 506, a company, there aren't information requirements so long as the issuer is selling solely to accredited investors. But again, in a 506B transaction, traditional 506 transaction, an issuer cannot use general solicitation, is selling solely to accredited investors, obviously cannot test the waters, and the securities that are sold are restricted securities. And the issuer is not going to be subject to any ongoing reporting requirements, but by the same token, doesn't develop the public market following. So in the example that I gave of a consumer offering or an affinity offering, it'd be hard to get that done to sell to customers unless you were assured that all your customers effectively were accredited investors. Okay. Well, at this point, I don't see any additional audience questions. I'm always happy to take questions by email. And on our blog, which is the MoFo Jumpstarter blog, we often just take a crack at answering questions that we get from clients. So feel free to follow that for additional information on Reg A.
Thank you, Anna. Appreciate you sharing your perspective on raising capital using Reg A in today's dynamic environment, and we'll accumulate any questions that have come in through the console as well, in addition to the one you were able to answer, and